Welcome back to The World This Week with me, Phil Rees. Well, another round of pre-trial hearings is taking place at the US naval base at Guantanamo Bay. Khalid Sheikh Mohammed, the self-confessed mastermind, and 4 other suspects accused of involvement in the 9/11 attacks are discussing a range of legal issues that remain unresolved and must be dealt with before the case can proceed to trial. Well, spectators watch the proceedings behind soundproof glass and hear the sound only about 40 seconds after a delay, so that a white noise machine can be turned on while classified information is being discussed. Well, on Monday, the white noise machine was activated without the prior knowledge of the military judge or anyone in the court. And he responded angrily, saying he's in charge of the courtroom. Well, the interruption from eavesdroppers, presumably the CIA, came as a defense lawyer referred to a secret overseas prison where the defendants were held before they were sent to Guantanamo Bay. As Amanda Thomas-Johnson reports, the farce of Guantanamo is apparently continuing.
11 years on, and Guantanamo Bay detainment camp is still in operation. Thus far, justice has been hard to come by at Guantanamo, where alongside routine interrogations and tortures, rules governing trials are stacked firmly against inmates. However, the pre-trial hearing for those accused of plotting the September the 11th attacks have begun in earnest. This has been dogged with controversy after an audio feed allowing spectators outside the courtroom to hear was cut by a third party without the judge's permission. Judge Army Colonel James Pohl then said, "This is the last time any other third party will be permitted to unilaterally decide that the broadcast should be suspended." Furthermore, defense lawyers also claimed that their private conversations were being monitored by the CIA, a claim dismissed by the judge. There's also the wider debate over whether Guantanamo will actually be closed. An election promise made by Barack Obama is still outstanding. Though some have argued that Congress has blocked his intents, there are questions regarding Obama's will. This week, he dissolved the office of the Special Envoy responsible for closing down Guantanamo. With the treatment of inmates and the conduct of its court both causes of serious concern, it remains to be seen what good Guantanamo can bring to the US's global standing. Amanda Thomas-Johnson, Islam Channel.
Well, thanks, Amanda. Well, today I'm joined by Terry McGuinness, a lawyer at Garden Court Chambers and an international law specialist. We also have Hilary Stauffer, the Deputy Director and Head of the War on Terror Unit at Reprieve. Thank you both for joining us. Terry McGuinness, I mean, what did you make of this episode in court this week when even the judge and certainly the security officer of the court, nobody knew who was putting on this white noise? I mean, it's kind of ridiculous, isn't it?
Well, it is. The problem, before this story broke, there was already serious concern as to the extent to which these proceedings were proceeding in secret. And then what's significant about this story is that it appears that the judge, the military judge, Colonel Pohl, it appears that both he and his court security officer were unaware that there was a government agency with the power and means to censor essentially what was happening in his courtroom.
Because, I mean, the mechanics of it, I mean, I tried to explain it earlier. You know, there is, members of the public sit behind a wall and there is a delay, so they can see things, but they can't hear things for some 40 seconds. So here the judge is there, and he didn't realise that this noise, I'm presuming a button is pressed and bzzz, it all starts. Yes. And you know, they must have been shocked then, and they didn't realise that this could be done from, presumably, Langley or from Washington or from miles away.
Well, it is being done by somebody other than the judge who's meant to be presiding over those proceedings and ensuring that they remain fair. So if another branch of the executive who's bringing the prosecution can then censor what's happening in the court, it really calls into question just what control the judge has over these proceedings and how he can maintain any semblance of fairness in these proceedings.
I mean, the judge has said he's had enough and he's going to stop this. Do you think he'll have the power to do that?
Well, the question is, he was unaware of this agency's power to censor what is happening in his courtroom. It took him by surprise. So, firstly, we have to question what else does he not know? Will he have the power to stand up to whichever agency is doing this? Because he himself is a Department of Defence appointee. And then this whole incident throws into even starker relief the absence of the principles that we would deem to be hallmarks of a fair trial.
Yeah. Well, I mean, Hilary Stauffer, I mean, we can perhaps, laugh at it, but I mean, people's lives are at stake and principles of justice are at stake here, aren't they? And I think this incident perhaps does suggest that the whole thing is not worth, the sort of paper it's written on in terms of a fair trial. Is that fair?
I think that is an accurate description. I don't think this could be described in any way as a fair trial. This is something the government has cobbled together step by step because they won't try them in ordinary civilian courts, which they very well could. And so they're just making it up as they go along, and they're not making it up very well. In this particular incident, what's particularly troubling is that the prosecution seemed to know something about what was going on, but the judge didn't. So the judge said, I don't know who's censoring this, I didn't say anything. And the prosecutor said, we can talk about that, outside in chambers, basically. So the prosecutor can tell the judge that his court's not being censored. That means the deck is stacked against the defense from the start, as if it wasn't already.
I mean, I think viewers would probably be interested to just learn a little bit, go back a bit as to what happened if we go back to 9/11, Guantanamo was set up. And it was set up on this odd bit of land where there's a US naval base in Cuba. I mean, in Cuba, of all places, of course, which itself is sort of ironic. Who owns it? I mean, George Bush thought this was a kind of legal black hole that, in fact, they could torture people and get away with it, didn't he?
He did. I mean, Guantanamo has a very unique status in that it is a U.S. military base, and generally that's considered sovereign territory of the country that owns it. But there's an indefinite lease between the U.S. and the previous Cuban government from 100 years ago. I mean, it's a very odd arrangement, saying that this bit of land never has to be given back. And obviously, the U.S. doesn't have any relations with the current Cuban government, who I'm sure would love it back, would love to have this little bit of land back. But it's just an odd little space. And
so no law applies there. That's the principle behind it.
That's the argument. Certainly, civil rights groups have fought back against that, and Supreme Court did fight back against that in cases like Boumediene, saying, no, this is not a legal black hole. These people have to be able to challenge their trials. This was in 2008 in habeas corpus proceedings.
This is the gentleman from south of France,
that's
now,
correct.
Who's now free, of course, had no charges against him, despite his name being discussed by George Bush publicly in a State of the Nation speech in 2002. He's now a free man, I think, in the south of France. But so you're saying about the generally then that is that argument. Was George Bush wrong there, do you think? I mean, how do the courts see that, the status of Guantanamo today?
George Bush was wrong. No, I mean, the status of Guantanamo today is that it is a U.S. military base. The problem is trials are not usually held on U.S. military bases under a new legal regime that they've made up. I mean, the trials that are held on U.S. military bases usually are under the Uniform Code of Military Justice because they're trying military personnel. They're not usually trying other people. If they were trying other people in an ongoing conflict, it would be as a prisoner of war. But they've said specifically that people at Guantanamo are not prisoners of war. They are enemy combatants, which is an entirely new status that nobody else agrees with and nobody else thinks has any legitimacy to it. So that's why these trials are being completely made up as they go along.
Now, I mean, just following on in terms of the history, I mean, President Obama, of course, before his election in 2008, promised to close Guantanamo. Well, Terry McGuinness, I mean, what happened there? I mean, obviously, he did try, didn't he? Or did he not?
He tried. In the first week of his presidency, he signed 3 executive orders that are all related to how the US is prosecuting its war on terrorism. And the first of those orders was that the detention facility on Guantanamo was to be closed within 1 year. And he requested $80 million from Congress to fund that, to fund the moving of the prisoners and the de-establishment and the removal of the base, or of the detention facility. 4 months later, the US Senate voted on this, and they voted overwhelmingly against giving him the funds that he required. They voted 90 votes to 6. And that was a Senate controlled by his party, the Democrats. And it was seen, and it was a very sharp rebuke of the president. And what his own party leaders in the Senate said was that, yes, we agree with the president that Guantanamo is not helping us in the war on terror, but we are not going to move any prisoners until there's a plan in place for where we're going to put them and how we're going to prosecute them. And ever since, Congress has added restrictions to an annual defence spending bill, which means that Obama is forced really to sign into law restrictions preventing him from removing prisoners from Guantanamo, preventing him from shutting the base down, And if he vetoes that bill, then the Defence Department and how it spends its money will be severely restricted. And for a president who's waging at least one, maybe two wars at the moment, he's forced into a position he doesn't want to be in.
Because, of course, he did announce very publicly in November 2009 that Khalid Sheikh Mohammed and the various 4 or 5 others directly involved or being accused of being involved in plotting 9/11 would be tried in New York. That has seemed to be going ahead. That was a positive move, wasn't it, Hilary Stauffer, in the sense of actually now they would come before a court of law.
Exactly.
Well, what happened to that?
It was a very positive move to bring them into the U.S. civilian court system, what we call Article 3 courts, and it would have been a great sign that the U.S. was serious about giving these guys a fair trial. I mean, these are allegedly the worst of the worst. This, like, as you said, Khalid Sheikh Mohammed, who is the self-confessed terrorist mastermind, they have lots of evidence against him. Of course, most of it was gotten by waterboarding and torture.
Well, he was waterboarded 183 times,
yes,
I think.
Indeed. But they say they can try these cases without a problem. So bringing them into the civilian court system would have sent a very strong signal that the U.S. was going back on track to living up to its obligations and its values. And instead, I think there was a lot of pushback from Congress, among others, who basically said, and this includes Democrats and Republicans from across the board, nobody wants to be seen as welcoming terrorists to American shores, which is ridiculous because terrorism trials are conducted in the U.S. every day in the civilian court system. It very easily could have done. It was a political decision.
Now, of course, just as we heard in Amanda's report earlier, I think David Fried, the special envoy for closing the Guantanamo, Daniel Fried, I'm sorry, yeah, he was moved to another job. So I think his attempts to close it, as it were, case closed.
Well, Daniel Fried's office was more, indeed, that's a distressing sign from the Obama administration that they are less serious than ever about closing Guantanamo. Dan Fried was mainly in charge of trying to resettle Guantanamo detainees and to repatriate them to their own countries or resettle them into third countries. And so, yes, if the special envoy for the closure of Guantanamo has been shifted to another job and that position is being sent to the State Department, to the Office of the Legal Advisor at the U.S. State Department, whom there isn't currently somebody in that position, which means everything is held up until at least the political appointments get made in the U.S. It's just a terrifying prospect for these men. They're never getting out of there.
Well, yeah, that is a terrible thing to say. I mean, can we widen the discussion now? I mean, Terry McGuinness, I mean, obviously, you know, we've seen recently about certain leaks about President Obama's legal justification for extrajudicial killings, for executions. They were leaked to the American media, and now I think he's actually providing some documents regarding terms of reference for legally killing people abroad. I mean, how do you see the way international law is evolving now when it comes to, you know, before there were wars, there were laws of war, there were Geneva Convention and all that. Are we seeing some fundamental change now? And is it in any way justified?
I don't think it is justified. And I don't think the laws of war themselves are changing. The United States has refused to abide by them. And there's powerful evidence that international humanitarian law has been consistently breached and violated by the United States since 9/11. But I don't think it's being undermined as such as violated, because there is a pushback. And I think other states have asserted their commitment to abide by the international rule of law. And the NGO community in America, and indeed here, like groups like Reprieve, consistently hold America to account.
Yeah, but isn't the argument that America has, in a way, that in the past there was a battlefield, you know, you had the enemy here, you had a defined battlefield, but now with what they call terrorism, what they define as, you know, attacks on American personnel and American property, etc., around the world, that this mode of military action can happen anywhere, and therefore the whole world is a battlefield, and therefore they can just, you know, choose to kill somebody on a street, and that is fine, just like killing an enemy combatant down the sights of a sniper rifle, for example.
Well, dealing with that last point, the rules haven't changed. America is claiming that how it fights its wars has to change. But the rules are quite clear, and America is violating them when it enters the airspace of another country or when it sends drone attacks into Pakistan. But this is also the justification for having military commissions rather than civilian trials for those in Guantanamo, They say that these are groups that are evasive, they're hard to engage with, and therefore civilian courts can't be used. Now, if we put to one side for the moment the fact that the courthouse on Manhattan Island has successfully prosecuted lots of terrorists, from those that tried to bomb the World Trade Center in '93 right through to 2009. Groups like the American, so putting that aside for one moment, the American criminal justice system, this is not unknown to it. It has engaged with groups like the Mafia and the Ku Klux Klan, domestic terrorists, who have been just as evasive and who America has had difficulties in prosecuting because, like in this country, there will be undercover operations against them, and prosecuting somebody might give up those operations. But it successfully overcame them, and it did so within the rule of law. And it's convenient for America to put the rule of law to one side for a moment in international affairs, but it doesn't have to, and it shouldn't.
Well, I mean, we have seen, particularly, talking about America, but we've seen in Britain, Hilary Stauffer, we've seen a decade or over a decade now of what the government calls terrorism legislation, anti-terrorism legislation. Of course, it never defines who exactly is a terrorist, but it lists groups, and usually groups that are enemies of the British state, that are terrorists, and therefore it feels that these people can come under those laws. But it sort of tried to rewrite some of the most fundamental things, including, of course, habeas corpus. It's tried to change some of the very basic principles of a legal system that's been in place for years. Of course, indefinite detention was brought in by Tony Blair for a while. I mean, how do you see this in the broader picture of where we are, today? How serious is this kind of threat to our liberties, and why has this resulted just from 9/11?
It is from 9/11. It is from everyone being just so scared, especially in America. I'm from Washington, D.C. I lived very close to the Pentagon. I was there on 9/11 when it happened. And people, it was a threat to America. We feel invincible in America. We're a huge country in the middle of two oceans, and there hasn't been an attack on American soil since Pearl Harbor. So it was very scary at the time, and everyone overreacted. And things like the DOJ, the Department of Justice white paper that you referenced earlier and Terry was talking about, are a terrible, terrible precedent, because basically this is America rewriting its own rules. And but America can rewrite its own rules mainly because right now America is, the big dog in the room. But if America can rewrite its own rules, can everybody rewrite its own rules? And then is there no more international law? Is there no more law of war? I mean, in the DOJ white paper, which was about the U.S. killing its own citizens abroad, they have single-handedly stretch the definition of imminent attack to be absolutely meaningless. And they've also said that a non-international armed conflict, which has a very specific definition under the Geneva Conventions, now basically stretches to anywhere in the world that an al-Qaeda operative might be. And those things cannot stand. And if another country outside the United States, outside of Britain, if Russia or China or Iran tried to come up with their own international law rules and just promulgated them independently, there'd be an outcry. But the U.S. just acts independently because it can. And this is going to be Obama's Guantanamo. This is going to be, Obama published and the Bush torture memos saying this is terrible and we need transparency and we'll never do that again. But he won't give us transparency on his own secret of war. That's very problematic.
Because we are talking about a crucial part of this, of course, in many of these attacks, many of these arrests, is the imminent threat, isn't it? And of course that goes back to Article 51 of the UN Charter that gives a country a right to defend itself, that principle that violent action is approved. But, of course, the US has invoked that when it attacked Grenada, for example, and Panama, countries that you wouldn't suspect. So there's been that continuum, though, hasn't it, that it can now say that it is under threat from anyone and simply attack anyone.
Self-defense is an elastic concept, or it can be in international law, and there isn't a tried and true answer for this. But the way that they are interpreting it now is certainly very problematic in the scope of international law at large and in the scope for Western values and Western democracy.
Well, let's just go back now, finally, to the trial, and obviously Khalid Sheikh Mohammed and these, I think, 5 or 6 people, is it, who are directly involved with this. How are we going to see that unfold? Is there going to be a trial? These are pre-trial hearings now. They're discussing procedural matters. So what exactly is going on now, and when will that trial likely happen?
Well, one of the implications of not having the trial in the civilian courts, where other terrorism trials have been, is that these military commissions will have to devise their own rules, their own procedures, and will have to approach afresh all these different interlocutory questions, these preliminary questions of law.
Yeah, there's no precedent really, is there?
Well, there's not. And in doing so, a judge can't say, well, this is how it's always been, this is how we do it, so that's how it's going to happen here. For example, last year, Khalid Sheikh Mohammed asked for permission to speak at one of these preliminary hearings. And this sent the whole military commission into such a panic because it had no set rule on what should happen should a defendant want to speak. And so it adjourned. And one of the reasons that there are these colossal delays is that it's trying to create its own rules, its own procedures. And I don't think we'll see a trial for another at least 12 months because there are so many preliminary issues that will have to be resolved first.
I mean, what's the United States trying to achieve here? If it shows itself up to farce, shows the legal system that it's trying to create here is, you know, a real fraudulent legal system. I mean, what is the point of it all?
There doesn't seem to be much of a point to it. I think, in my opinion, what is going on is they didn't expect to have quite such good defense lawyers, to be honest. The system is entirely stacked against the defendants, and with the military commission trials, the 9/11 trials that we keep talking about, these are essentially death penalty trials. I mean, these guys are definitely going to be found guilty. So the question is, are they put to death, or are they kept in a supermax prison for the rest of their lives, probably in Guantanamo? So it's not a question of guilt or innocence, it's a question of death penalty or not, really. And the entire system is biased towards the prosecution, and more the prosecution than the judge even, and the defense lawyers are appointed by the military. But many of these guys, many of the defense lawyers have turned out to be impassioned advocates because they see themselves as working in a system that is just so unfair. They didn't join the military in order to participate in farcical trials. I mean, there's all...
Because the defense lawyers are members of the military as well.
They are. They're called judge advocates, JAG lawyers. And so, I mean, they're just the military lawyers. So they defend everybody from drunk driving accidents to murder within the Uniform Code of Military Justice to other things which go on on military basis. Or some of them have international law experience on the battlefield. But I think none of them joined thinking they would be appointed to uphold a farcical, fair trial system of their government. And they've become impassioned advocates on behalf of their clients. And I think that's one reason the court keeps finding itself caught out. They just weren't expecting this much pushback from the defense. I think they thought this would all be over in a few
They thought it would be
months.
A shoo-in, you mean? This was just be a ritual,
that's what I think
to legitimize a death sentence, really.
Certainly that's what everyone's aiming for. So what the pretrial motions right now, there's a lot of them right now. In addition to the 9/11 hearings, there's someone for the USS Cole bombing. It's al-Nashiri, and he's a separate defendant in a separate case. And he right now, his defense lawyers have said that he needs to be an independent doctor, needs to identify whether or not, what he's suffering from post-traumatic stress from torture, because he suffered terrible torture as well in his interrogations. And if that is agreed, then that could go towards mitigation evidence in the sentencing phase, so whether he gets death penalty or not. Does the torture mean that they're not eligible for the death penalty? That's really what we're fighting over here.
It seems the law is getting in the way, Terry McGuinness, of the trial they wanted.
Well, I think that's what it's about. If there wasn't something to hide, these trials could easily have been conducted in the federal court in Manhattan. That's where Obama and his Attorney General Holder wanted to have them, and they moved them back to Guantanamo.
Okay, well, listen, as I say, thank you both for joining us. We'll be watching that space, as it were. Thank you to everyone. We'll be on again next week. Try and join us if you can, same time. Assalamu alaikum.